Hello and welcome to the Minimum Competence episode for Wednesday, June 4th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Girardi's prison sentence, Trump's attack on birthright citizenship, RFK Jr. and Musk sued over mass firings, and a White House GAO spending showdown. Let's remember, literature is the question minus the answer, and read today's legal news. On this day in legal history, June 4th, 1919, the U.S. Congress passed the 19th Amendment, marking a turning point in American constitutional and civil rights history. The amendment stated simply that the right to vote shall not be denied or abridged on account of sex, legally enfranchising millions of women. The road to this moment was long and contentious, spanning more than 7 decades of organized activism. Early suffragists like Elizabeth Cady Stanton and Susan B. Anthony laid the groundwork in the 19th century, while a new generation, including Alice Paul and the National Woman's Party, employed more confrontational tactics in the 1910s. Although the House of Representatives had passed the amendment earlier in the year, the Senate had repeatedly failed to approve it. The June 4th vote in the Senate, passing by just over the required two-thirds majority, was the final congressional hurdle. The legislative victory came amid shifting national sentiment, in part due to women's contributions during World War I and growing pressure from suffrage organizations. The amendment was then sent to the states, needing ratification by 3/4 to become law. That process concluded over a year later when Tennessee's pivotal ratification on August 18, 1920, signed the amendment into law. The 19th Amendment was certified on August 26th, finally making women's suffrage the law of the land. This day marks not just a legal transformation, but the culmination of one of the most significant civil rights struggles in U.S. history. Disbarred attorney Tom Girardi was sentenced to 87 months in federal prison for stealing $15 million in settlement funds from his clients. U.S. District Judge Josephine Stanton had also imposed a $35,000 fine and ordered Girardi to pay over $2.3 million in restitution. The sentence followed his August 2024 conviction on 4 counts of wire fraud. Girardi, who turned 86 on the day of his sentencing, had sought leniency due to age, liver issues, and dementia claims, but the court found him competent and sided with prosecutors who sought a significant term. Girardi's legacy was once tied to his successful pollution suit against Pacific Gas and Electric, dramatized in the film Erin Brockovich. However, his downfall involved stealing settlement funds in various personal injury cases, including millions owed to families of victims of the 2018 Boeing 737 MAX crash. A federal judge in Chicago recently dismissed related charges, citing the active California case, though the prosecution of Girardi's son-in-law, David Lira, is still set to proceed there. Lira, for his part, denies any wrongdoing. At trial, Girardi blamed the fraud on Christopher Kamen, his firm's former CFO, who has already been sentenced to over 10 years after pleading guilty. Girardi's attorneys continue to claim cognitive decline, but the court maintained that he was mentally fit to face justice. A federal appeals court is set to hear its first case reviewing the constitutionality of Donald Trump's executive order limiting birthright citizenship. The 9th U.S. Circuit Court of Appeals will hear arguments in Seattle as the Trump administration appeals a nationwide injunction issued by U.S. District Judge John Coffenauer, who called the order, quote, blatantly unconstitutional. The directive, signed by Trump on January 20th, his first day back in office, seeks to deny citizenship to U.S.-born children whose parents are neither U.S. citizens nor lawful permanent residents. Critics, including 22 Democratic attorneys general, immigrant advocacy groups, and anyone with a soul, argue the order violates the 14th Amendment, which has long been interpreted to grant citizenship to nearly anyone born on U.S. soil. Federal judges in Massachusetts and Maryland have also issued rulings blocking the order. Meanwhile, the Supreme Court, which heard related arguments on May 15th, is considering whether to limit lower courts' power to issue nationwide injunctions rather than deciding on the constitutionality of the policy itself. If implemented, the order could deny citizenship to over 150,000 newborns annually, according to the plaintiffs. The lawsuit before the 9th Circuit was filed by several states and individual pregnant women. The 3-judge panel includes 2 Clinton-era appointees and 1 Trump appointee, potentially shaping the outcome. The administration maintains that birthright citizenship doesn't apply to children of undocumented or temporary status immigrants, a stance at odds with long-standing interpretations of the 14th Amendment. And to be clear, this case revolves around the citizenship clause of the 14th Amendment. This clause states, quote, all persons born or naturalized in the United States are citizens of the United States, which forms the basis of birthright citizenship. The case centers on how the clause should be interpreted, making it the key constitutional question in this challenge. On the side of birthright citizenship is, frankly, the plain language of the amendment. On the side of the executive order are racists and racist people without basic reading comprehension, full stop. There is no other side here, and there is no real debate. Ultimately, the courts may decide to pretend there is some nuance, but that changes nothing about the clear language of the actual amendment. All persons born or naturalized in the United States are citizens of the United States. A group of former U.S. Department of Health and Human Services, or HHS, employees has filed a class action lawsuit against HHS Secretary Robert F. Kennedy Jr. and Elon Musk, alleging that their departments used flawed data to justify the firing of 10,000 federal workers. The lawsuit, filed in the U.S. District Court for the District of Columbia, claims that HHS and the Department of Governmental Efficiency, or DOGE, which Musk leads or led, violated the 1974 Privacy Act by using inaccurate personnel records during a mass reduction in force, or RIF. The plaintiffs argue that the agencies relied on data riddled with errors, including incorrect performance reviews, job descriptions, and office locations. One named plaintiff, Katherine Jackson, reportedly received an RIF notice based on false performance ratings. Another, Melissa Adams, was allegedly terminated by officials who didn't even know her work location. The lawsuit seeks at least $1,000 in damages per affected employee and a court declaration that the government's actions were unlawful. The complaint also suggests that the terminations were ideologically driven, referencing a troubling incident where an FDA employee was warned by a man invoking DOGE shortly before receiving her RIF notice. The mass firings, which began April 1st, impacted key HHS agencies like the CDC, FDA, and NIH. Kennedy defended the cuts as part of a broader reorganization to address chronic disease. The plaintiffs, however, see the action as a politically motivated purge that disregarded legal safeguards. By way of brief background, the Privacy Act of 1974 mandates that federal agencies maintain accurate records when making decisions that adversely affect individuals. It is central to the lawsuit because the plaintiffs claimed their terminations were based on data that was factually wrong, violating this statutory requirement. A new conflict over federal spending power is emerging between the Trump White House and the Government Accountability Office, or GAO, centered on a $5 billion electric vehicle infrastructure program. The GAO recently concluded that the Trump administration's pause of the National Electric Vehicle Infrastructure, or NEVI grants, originally authorized under President Biden's 2021 infrastructure law, violated the Impoundment Control Act of 1974, which prohibits presidents from withholding funds for policy reasons. In response, the White House issued a sharply worded memo instructing the Department of Transportation to disregard the GAO's opinion entirely. The memo, written by OMB General Counsel Mark Paeta, accuses the GAO of partisan bias and undermining President Trump's, quote, historic and lawful spending reforms. It signals a broader strategy to challenge the authority of congressional watchdogs and reframe presidential control over budget implementation. This dispute could serve as the first legal test of Trump's intent to challenge the constitutionality of the Impound Act itself. The delay in EV funding is part of a broader rollback of Biden-era policy priorities, including guidance on equity and charge replacement. Meanwhile, the administration has proposed over $9 billion in spending rescissions aimed at areas like public broadcasting and foreign aid under Trump's Department of Government Efficiency initiative. Advisors have floated a tactic called pocket rescission, a timing strategy that critics argue violates legal requirements for obligating federal funds. This isn't the first time a president has clashed with GAO over spending powers. Trump and Biden both previously faced scrutiny for pauses in Ukraine aid and border wall funds, respectively. However, the White House's open defiance of GAO marks a significant escalation in an ongoing constitutional debate over who ultimately controls this federal purse. More specifically, the Impound Control Act of 1974 restricts the executive branch from withholding or delaying funds Congress has appropriated unless explicitly authorized to do so. It plays a central role in this dispute as the GAO argues Trump's delay of NEVI grants constitutes an illegal impoundment, while the administration disputes the law's constitutionality and the GAO's oversight role writ large. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, interpretation is the revenge of the intellect upon art.